Hi, my name is Ms. Sherry Johnston. My class is Legal Aspects of Media, and this coverage we will be discussing today is defamation of character. On the second slide, you will find New York Times versus Sullivan overview. The party in this particular case were the plaintiffs L.B. Sullivan, who was one of the top 3 commissioners in Montgomery, Alabama. The defendant in the case was the New York Times Company. The case was brought into the court because Mr. Sullivan claimed that he was defamed in a full-page ad that was printed in the New York Times. The advertisement was centered around the civil rights movement in Montgomery, Alabama, and the title of the ad was Heed Their Rising Voices. The advertisement began by stating that as the whole world knows by now, thousands of Southern Negro students are engaged in widespread nonviolent demonstrations and positive affirmations of the right to live in human dignity as guaranteed by the U.S. Constitution and Bill of Rights. It went on to charge that in their efforts to uphold their guarantees, they are being met by unprecedented waves of terror by those who would deny and negate the documents which the whole world looks upon as setting the pattern for modern freedom. Succeeding paragraphs reported to illustrate the wave of terror by describing certain alleged events. The text concluded with an appeal from the fund for 3 purposes: support the student movement, the struggle for the right to vote, the legal defense of Dr. Martin Luther King, the leader of the movement against perjury. On the third slide, you will find a picture of the article and a picture of Sullivan, who was the police commissioner. On the fourth slide is the elements of defamation. Sullivan claimed that the advertisement referred to him indirectly because of the oversight responsibility over the police in Montgomery, Alabama. New York Times informed the court that the ad did not mention Sullivan's name. In the 10th paragraph of the article that was published, there were 6 statements that were biased of Sullivan's claim. In Montgomery, Alabama, after students sung My Country 'Tis of Thee on the state capitol steps, their leaders expelled from school and truckloads of police arms with shotguns and tear gas rang the Alabama State Student Campus. When the entire student body protested the state's authority by refusing to re-register, their dining hall was padlocked in an attempt to starve them to submission. In the 6th paragraph of this article, it quoted, "Again and again, the Southern violators have answered Dr. King's peaceful protests. In intimidation of voice, they had bombed his home, almost killing his wife and children. They assaulted him and they have arrested him for perjury and a felony under which the imprisoned for 10 years. Although neither one of these statements mentioned Mr. Sullivan by name, he contended that the word police in their 3rd paragraph referred to him as Montgomery Commissioner, who survived the police department, so that he was being accused of ringing the campus with police. He further claimed that the paragraph would not be read in putting to the police, hence to him padlocking the dining hall in order to starve the students in submission. As the 6th paragraph, he contended that since the arrests were orderly made by police, the statement they have arrested Dr. King 7 times would read as referring to him in the capacity of a commissioner. The 5th slide, will be the Supreme Court decision. After reviewing the case and the factual information in the case, the errors in the ad in the lower court judgment, Brand announced that the court had found the rule applied by Alabama courts failed to uphold freedom of speech, and of this press that are required for First and 14th Amendment. Brand quickly disposed of Sullivan's relevance on an earlier decision of the courts and cited that several previous cases had appended and promised to First Amendment. The legal case, the Supreme ruled unanimously 9-0 for a liberal suit to be successful. For the complainant must prove the offending statement was made with actual malice. that is with knowledge that it was false or reckless disregard of whether it was false or not. Specifically, the case involved an advertisement that appeared in the New York Times. All in all, the defendant, Mr. Sullivan, won the case for $500,000. The next case that we will be covering is Gratch versus Welch. The parties that were involved in this case were Elmer Gratch and Robert Welch. Gratch was a well-known attorney in the Chicago area who was hired to represent a family of a youth, Robert Nelson, who was shot by a Chicago PD, Ronald Nico. Welch, a leader of an unconservative John Branch Society and publisher of American Opinion magazine. Even though Gratch seemed to be a public figure, he was actually a private and notable lawyer in Chicago. The case was filed inside the court because an article appearing in Respondents magazine alleged that Nico's murder trial was part of a communist conspiracy, discredited the police, and falsely stated the petitioner had arranged Nico's frame-up, implied the petitioner had a criminal record, and labeled him a communist fronter. The petitioner brought the diversity libel action against the respondent. The article also stated that Gratch was an officer of the National Lawyers Guild. Gratch filed a diversity action for liberal in the United States Court of Northern District, Illinois. He claimed that the falsehood published by the respondent injured his reputation as a lawyer and as a citizen living in Chicago. Before filing an answer, the respondent moved to dismiss the complainant for failure to state a claim upon which relief could be granted, apparently on the ground of the petitioner filed an alleged special damages. The district court denied the motion for summary judgment in memoriam of the September 16th. The court did not dispute the respondent's claim of protection of the New York Times standards. After reviewing both cases, it's very important to make sure you fact check your information, as well as make sure whoever you're interviewing signs a non-disclosure agreement, because this is how both magazines and personnel could have avoided the situations in which they went through when it came to their court cases. Bringing it into the Supreme Court, I feel as though it was a little bit too much, just for the simple fact of I feel like these cases were your First Amendment rights. Thank you. For the eighth slide will be Pennsylvania's defamation state laws. In Pennsylvania, the courts invoked the complied statutory definition found. Pennsylvania defines when a plaintiff is a public official and all public figures are limited purpose figures in more classes. And then if you look at the slide, it will describe what type of class is considered a public figure, what type of class is considered a private figure. But all in all, the Supreme Court in Philadelphia neither recognizes or rejects wire service defenses. So if you're doing a wiretap, the state of Pennsylvania does not recognize it. Lastly, you will find my resources that I use for my project. And that is it. Thank you for reviewing my legal aspects of media defamation overview and PowerPoint. Have a great day.